that what happened in this case was on 15th of this month, my lord. The common order was passed for removal of defects. One of the defects, my lord.
Please, what is your problem?
The problem with the
court master is asking you to give the slip.
Defective.
He has already allowed your mentioning. We don't allow mentioning. They are entitled to allow all mentioning. Every day I say this, please don't waste the court's time.
but only the
You have filed IA?
no, but that is the only that is the number of the case. I think the impugned order is wrong, and that cannot correct that.
Impugned order is wrong.
Yes, impugned.
So therefore you file your IA, we'll pass an appropriate order to that effect. You file an IA for ignoring that effect or for sending the impugned order before the learned could be correction.
Yes, that is
for that IA is required.
The IAS 29 which is that will not be preemptive, will not have to inform that it will come that.
The order was passed in open court in presence of everybody. I also called upon each council as if they want any separate order.
That's right. But
you file your IA today itself. You can't do anything.
This case item 8 permission criminal division 661 of 2020.
Mentioning regarding withdrawal of writ petition.
You want to withdraw?
Out of list है.
Out of list.
Are you sure? This 661 of 2022.
No, your Lordship. He is mentioning another case.
Out of list matter.
Out of list.
आपके सामने कौन सी भाषा में बोले हिंदी इंग्लिश बंगला When I tell one council that you give your mentioning and by default all mentioning are to be allowed, why do you need to mention it once again? Where is your slip?
Thank you.
You have put your date?
Yeah.
It will come on that.
Item 8.
Petitioner. This revision is not needed. This is against acquittal
Yes, sir.
passed by the appellate court.
Yes, sir.
Explain. Where are those judgments? There is no Sundar Singh wala hai, us file mein hai judgments.
In view of the full bench
In
judgment,
view of the full bench also.
Tuklal
it is not
Yadav, yes.
maintainable.
Tuklal Yadav, yes,
Yes.
sir. 2018,
Are you
volume 4,
there?
DLDR
Are you there?
245.
This is not maintainable. So therefore, under such circumstances, I will say that it is not maintainable. It is maintainable.
Yes, your lordship.
Are you satisfied that it is?
Yes.
You have read the judgment?
Yes.
And you have read the recent judgment of the Honorable Supreme Court?
Yes, Joseph Stephen.
Yes. Kindly satisfied that it is not.
Your lordship, first of all, since I am recovering from a brain hemorrhage, I am maybe a bit slow. You'll have to clear
No problem. You just tell us. Yesterday only I told you some counsel who was there. You satisfied that it is maintainable? Get that. Record आज का दिस सप्लीमेंट कल से आ जाएगा इसमें मुझे एक क्वेश्चन का लगेगा क्लियर है पहले वो वाला
बुला लिया तो
नहीं उसके पहले और
उसके बाद
जोसेफ स्टीफन
ये
What's that? Because that is recent and after the judgment passed. Yes.
Lordship, these cases pertain to the acquittal by the trial court itself, not by the appellate court. If
Let us see the facts of the Joseph Stephen.
Yesterday, I have served the copy of it.
Yes, it is.
even after the Joseph Stephen and Tuklal Yadav, the matter has been decided by our own High Court in double bench.
When it comes to, please refer to the facts of the judgment passed by Honorable Supreme Court in case of Joseph Stephen. Yes,
Para 2 and 2.
Para 2, let me read it.
The facts leading to the present bill in nutshell are as follows: that all the original accused were charged and tried for the offences punishable under 147, 48 and 26 such as that the Chief Judicial Magistrate Judicial Appellate by judgment dated such and such convicted the accused under the aforesaid offences except under section 307 and 506 and thereby acquitted the accused under 306.
False. Partly acquitted, partly convicted. Continue.
Feeling aggrieved and dissatisfied with the judgment and order of conviction passed by the Chief Judicial Magistrate, the accused referred criminal appeal number in the court of such and such, challenging the acquittal of the accused under the section 307 and criminal law. So, Your Lordship, in this case,
So the order of acquittal was
challenged.
challenged. There were two criminal appeals. One filed by the victim or the complainant, and other was filed by the accused.
Those were all against the conviction.
No. One was against acquittal also, because they were partly acquitted by the trial.
The first appellate court by the judgment dated such and such allowed the appeal preferred by the accused and acquitted the accused. The criminal appeals filed by the victims against acquittal of the accused under section 307 and 562 IPC came to be dismissed.
So the acquittal of accused for the offence for which he was convicted by the trial court, right, was allowed by the
Appellate
first appellate court.
Yes. Feeling aggrieved
So
and
this acquittal is by the first appellate.
yes.
Then
Then feeling aggrieved and dissatisfied with the common judgment and order passed by the first appellate court, allowing criminal appeal number 7 preferred by the accused, the victim's private respondents herein preferred criminal revision number such and such before High Court under section 397 and read with section 401 CRPC. By the impugned judgment and order while exercising the revisional jurisdiction under section 401 CRPC, the High Court has set aside the judgment and order passed by the first appellate court allowing criminal appeal number such and such and acquitting the accused, and consequently has convicted the accused for the offences other than offences under section 307 and 506 IPC, and has resorted the judgment and order of conviction and sentence passed by the trial court. The High Court has however modified the
so
sentence.
it was the revision filed by the victim, which was a conviction by the appellate court and revision filed by the victim has been allowed by the appellate. Now you come to para 10.10.
Okay.
10.2.
As observed by this court in the case of Mallikarjun Kodakali, so far as the victim is concerned, the victim has not to pray for ground of specific to appeal. As the victim has a statutory right of appeal under section 372 proviso, and the proviso to section 372 does not stipulate any condition of obtaining special leave to appeal under subsection 4 of section 378 CRPC. In the case of a complaint and in the case where an order of acquittal is passed in any case instituted upon the complaint. This is regarding the first court. The right provided to the victim to prefer an appeal against the order of acquittal is an absolute right. Therefore, as far as issue number 2 is concerned, namely in a case where the victim and the complainant, as the case may be, has not preferred and or availed the remedy of appeal against the order of acquittal as provided under section 372 CRPC or section 378 as the case may be, the revision application against the order of acquittal at the instance of the victim or the complainant as the case may be shall not be entertained, and the victim or the complainant as the case may be shall be relegated to prefer the appeal as provided under section 372 or section 378(4) as the case may be. Issue number 2 is therefore answered accordingly.
So in this particular case, the order of acquittal was passed by the appellate court, and this is what the Honorable Supreme Court has said. And when we see the proviso of section 372, it does not qualify the court to be the trial court or the appellate court. So whether a leave to appeal will be filed or not, or whether you will have a right to file direct appeal, is something which is subject matter of which will be subject matter of consideration by the Honorable Division Bench. Because a petition accompanied with leave to appeal as well as a direct appeal, both are to be considered by the Honorable Division. So we will not decide whether a leave is required or leave is not required. But the point is that this revision is not required. And it has said that as a case may be, shall not be entertained, the revision will not be entertained. It has been clearly stated. You just see, as the case may be, the revision application against the order of acquittal at the instance of the victim or the complainant, as the case may be, shall not be entertained.
Yes, Lordship, this
And
matter.
then you read the full bench.
Shukla.
Full bench of
Paragraph number is number 29, 40, question number 4.
you just come to para 46. Para 46, question number Roman 4, which is dealing with respect to complaint cases. And then question number 4, dealing with complaint cases, and you come to para number 8. Have you got para number 46?
The complainant, whether the state or a private person. Is it that?
No. The victims as defined under section 2.
The victims as defined under section 2WA of the CRPC, whether they are complainant or not, shall have the right to appeal under the provided to section 372 of the CRPC against the judgment order of convicting the accused for lesser offence or imposing inadequate compensation. In such cases also, if the order judgment is passed by the court of magistrate, the appeal shall lie to the court of session, in which case there shall be no requirement to seek any leave to appeal, and if the order judgment is passed by the court of session, the appeal shall lie to the High Court, subject to leave to be taken under section 373 of CRPC. It's on a different aspect of action.
Sub-para 7. I will come to sub-para 7.
In cases the victims are not a complainant, their cases cannot come under this section 374 of the CRPC. But here I am the complainant. This is not applicable. Such victims as defined under section 2WA of the CRPC can avail the remedy of appeal under the provided section 372 of CRPC. In such cases, if the order judgment of acquittal is passed by the court of magistrate, the appeal shall lie to the court of session, in which case there shall be no requirement to seek any leave to appeal. In the order judgment of acquittal is passed by the court of session, the appeal shall lie to the High Court, subject to leave to be taken under section 373 of CRPC. This is not our case. Our case is
You see, your case
is covered by
is covered by this
para 4.
Stephen's.
Para 4.
Yes,
The
sir.
Stephen's judgment.
No,
You come out of 10.2.
Stephen judgment. May I read this para 4 of this just one?
Which judgment you want to refer? There is one more judgment.
Tupla which we are reading.
Para number
Para number 4. With respect to appeals arising out of complaint cases. This is my case.
para number
4. Just दो पैराग्राफ पहले जो भी हम पढ़ रहे हैं.
अच्छा.
8 7 के पहले चलो. The complainant, whether the state or a private person who is also the victim, as defined under section 2WA of the CRPC, if agreed by the judgment order of acquittal passed by the trial court, shall have the only remedy against the order judgment of acquittal passed by the trial court to seek special leave of the High Court under section 374 of the CRPC, and in case the special leave is granted, to file appeal in the High Court. जब acquittal होगा तभी
by
जाना
the
है.
trial court.
Yes.
By the time.
But when the acquittal is by the appellate.
Appellate court. Then you appeal against appeal not maintainable.
No, it is not an appeal. You see, the first order of acquittal has been passed by the appellate court.
Yes. Then against the appeal, no second
It
appeal
is
can
not a
like
case. It is not a case where suppose there is an acquittal by the trial court, straight away leave to appeal to the High Court.
High Court. Yes.
Right?
Yes.
there is no first appeal
Yes.
before the lower court, right?
Yes.
If there is a conviction and if there is an appeal
Next.
and order of acquittal is passed for the first time by the appellate court,
Yes.
then it cannot be said to be a second appeal.
That has been dealt with the division bench thereafter, after this Joseph stay.
Where is that?
Joseph stay. क्या there was a bunch of 49 cases. ये एक भी citation बताते हैं.
Where is that order?
हम लोगों ने ये रेज किया था कि appeal against appeal cannot be there.
Where is that finding?
Para 10, page 13.
Para number?
10.
Where is the question thing? Para number 6. Right?
This court, after having considered the submissions advanced by the learned counsel for the parties, is required to consider as to whether the judgment rendered by Honorable Apex Court in the case of Joseph Stephen and Mallikarjun Kodagiri will be said to have prevailed over the judgments rendered by the full bench of this court in Tughlaqan. This court, in order to examine the same, is now proceeding to examine the case laws laid down by the full bench of this court in Tughlaqan vis-a-vis Joseph Stephen and Mallikarjun Kodagiri. The subject matter of consideration in Mallikarjun Kodagiri is the victims of the crime and their rights, and the same has been tested on the basis of provision as has been availed under section 372 and 378(4). The Honorable Apex Court, while considering the said issue at paragraph 76, held that the language of the proviso to section 372 CRPC is quite clear, particularly when it is contrasted with the language of section 378(4). The text of this provision is quite clear and it is confined to an order of acquittal passed in the case instituted upon a complaint. The word complaint has been defined in section 2D of CRPC and refers to any allegations made orally or in writing to a magistrate. This has nothing to do with the lodging or registration of an FIR, and therefore it is not at all necessary to consider the effect of a victim being the complainant as far as proviso to section 372 CRPC is concerned. It is thus evident that the Honorable Apex Court in the said judgment has considered the implication of section 372 CRPC. However, Honorable Mr. Justice Deepak Gupta as then was party conquering and party dissenting with the judgment has given his view at paragraph 95 that the right of the victim to file an appeal is not taken away or in any manner weakened only because he has to seek special leave to appeal. If section 378(3) and 4 and section 372 CRPC are read together, it is clearly clear that the victim is also required to apply for leave to appeal before this appeal can be entertained. It is thus evident that the consideration has been given in the judgment rendered by Honorable Apex Court regarding the victim's right, holding therein that the scheme of code of CRPC by insertion of the proviso to section 372 read with section 378(4) CRPC goes to suggest that due consideration has been given so far rights of victims are concerned, and as the said judgment cannot be said to overrule the proposition of law laid down by full bench of this court in Tughlaqan. The Honorable Apex Court in Joseph Stephen at paragraph 18, 3 issues for consideration. For ready reference, the same is reproduced here. Having heard the learned counsel for the respective parties, the following questions arise for consideration of this court. Whether the High Court in exercise of the revisional jurisdiction of section 401 CRPC is justified in setting aside the order of acquittal and convicting the accused by converting the finding of acquittal into one of conviction. Number 2, in a case where the victim has a right of appeal against the order of acquittal, now as provided under section 372 CRPC, and the victim has not availed such a remedy and has not preferred the appeal, whether the revision application is required to be entertained at the instance of the party victim instead of preferring an appeal, and where while exercising the powers under section 5 of section 401 CRPC, treating the revision application as petition of appeal and deal with the same accordingly, the High Court is required to pass a judicial order. The second issue which is of relevance here is that if a case where the victim has a right of appeal against the order of executor, now as provided under section 372 CRPC, and the victim has not availed such a remedy and has not preferred the appeal, whether the revision application is required to be entertained at the instance of party victim instead of preferring an appeal. Thus, the aforesaid issue in the context as to whether, even though the provision has been made after inserting the proviso to section 372 CRPC, giving a forum to a victim to file an appeal, the revision application is required to be entertained. The Honorable Apex Court, while answering the aforesaid issue, has been pleased to observe at paragraph 22 that it cannot be disputed that now, after the amendment in section 372 CRPC after 2009, and insertion of provision to section 372 CRPC, a victim has a statutory right of appeal against the order of executor. Therefore, no revision shall be entertained at the instance of victim against the order of executor in a case where no appeal is preferred and the victim is to be relegated to file an appeal. Even the same would be in the interest of victim himself herself, as while exercising the revisional jurisdiction, the scope would be very limited. However, while exercising the appellate jurisdiction, the appellate court would have a greater jurisdiction than the revisional jurisdiction. Similarly, in a case where an order of acquittal is passed, in any case instituted upon complaint, the complainant other than the victim can prefer an appeal against the order of acquittal as provided under subsection 4 of section 378 CRPC, subject to grant of a specific. For ready reference, paragraph 22 is quoted here and there. It cannot be disputed that now, after the amendment in section 372 CRPC of 2009 and the insertion of proviso to section 372 CRPC, a victim has a statutory right of appeal against the order of acquittal. Therefore, no revision shall be entertained at the instance of the victim against the order of acquittal in case where no appeal is preferred and the victim is to be relegated to final appeal. Even the same would be in the interest of the victim herself, as while exercising the revisional jurisdiction, the scope would be very limited. However, while exercising the appellate jurisdiction, the appellate court would have a wider jurisdiction than the revisional jurisdiction. Similarly, in a case where an order of acquittal is passed, in any case instituted upon complaint, the complainant can prefer an appeal against the order of acquittal as provided under section 4 of 378, subject to grant of a special. Further, the Honorable Apex Court at paragraph 23 has been observed by making reference of judgment rendered in Mallikarjun Kadagali that as far as the victim is concerned, the victim has not to pray for grant of a special leave to appeal, as the victim has a statutory right of appeal under section 372 proviso, and provision to 372 does not stipulate any condition of obtaining special leave to appeal like subsection 4 of section 378 CRPC. In the case of a complaint and in case where an order of acquittal is passed, in any case instituted upon complaint, the Honorable Apex Court therefore has held that two forums are available proviso to section 372 CRPC and 378 CRPC. For ready reference, paragraph 23 of the judgment is quoted as under. As observed by this court in the case of Mallikarjun Kadagali, so far as the victim is concerned, the victim has not to pray for grant of a special leave to appeal, as the victim has a statutory right to appeal under section 372 proviso, and proviso 72 does not stipulate any condition of obtaining special leave to appeal like subsection 4 of section 378 in the case of a complaint. And in a case where an order of acquittal is passed, in any case instituted upon complaint, the right provided to the victim to prefer an appeal against the order of acquittal is an absolute right. Therefore, so far as the issue number 2 is concerned, namely in a case where the victim under the complaint, as the case may be, has not preferred and or availed the remedy of appeal against the order of acquittal as provided under section 372 CRPC or section 378 as the case may be, the revision application against the order of acquittal at the instance of victim or complainant, as the case may be, shall not be entertained, and the victim or the complainant, as the case may be, shall be relegated to prefer the appeal as provided under section 372 or 378.
It is not dealing with the situation where the order of acquittal has been passed by the appellate court.
Maybe paragraph 10 and the 2. This court, after taking into consideration the judgment referred in Joseph Stephen vis-a-vis the issue involved in the present case, is of the considered view that the issue of maintainability of the appeal to be filed before the court after receiving 78.4 procedure was not subject matter of risk therein. It was not subject to risk therein.
We have seen the factual background of the case. The order of acquittal in that case was passed by the appellate court.
Yes.
You see, once the court says that the victim will have a right to file appeal against order of acquittal. It does not say that which court will pass the order of acquittal.
So since it is an acquittal by the sessions court,
Appellate court.
so naturally the appeal will lie to High Court.
Yes, certainly. I say that this revision is not maintainable.
But there is
You have to take appropriate remedy as per the provisions of section 372 or 378.4, whatever may be applicable, because I am not going to decide this whether 378.4 will apply or 372 proviso will apply. But this revision is not maintained.
then in this case,
And then you file an appropriate petition before the Honorable Division Bench, and then the Honorable Division Bench will apply whether leave would be required or it will be a matter of
now
right.
as particularly although it will lie before the single bench, not division bench.
So Tukla Yadav does not deal with a situation where the accused has been acquitted by an appellate court. It is not dealing with that situation.
But in the entire
So
CRPC,
if we see the factual background of this Stephens case, then the order of acquittal was passed by the appellate court, not by the trial. But still, the Honorable Court has said that the division will not lie. What will lie is the.
but also my submission is that there is no provision in the CRPC for appeal against appeal like civil cases a second appeal. So what will be considered? What
You
will be
just
the
see, you
title?
just read proviso to section 372. And senior advocate yesterday, Mr. A.K. Kashyap, had also addressed this issue.
Yeah.
He was appearing for the petitioner in the division petition. He also said that yes, this will not lie under identical circumstances.
It would set off in appeal.
Yes, it is there. Where is Mr. Surat? Yes.
I'm reading 372.
The 372. Yes.
Proviso, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or causing inadequate compensation, and such appeal shall lie to the court which an appeal ordinarily lies against the order of conviction of such court. This is pertaining to the trial court, Your Lordship. Court doesn't mean we are the appellate court also. Because if
Then you will have to seek leave to appeal under 378.4.
378.4 is not my case. It can be taken only when the first court acquits, not the appellate court acquits. Moreover, Lordship, there is no provision for appeal against appeal. What it shall be christened, the case title. There is because in the Tukla Yadav also there is been a categorization of cases.
But in the case of this Stephens,
Yeah, that is not been.
that was acquittal by the appellate court.
With due regard, that is in a way of per incurrum that is not being followed anywhere. That is why we had.
Per incurrium. You can say I can't say.
That is why it is not
You
being
can
followed.
say I can't say.
In the division bench also, where in the bunch of 29 cases we had put
The
for this.
issue was
also.
not in
Yes.
none of the cases. The issue was whether the appeal would where the appellate court has acquitted the.
Yeah, because in that case, in Joseph Stephens' case, matter was not properly put before the court, and the provisions of appeal and divisions were not
You can
contrasted.
argue that,
Not
but I
contrasted.
cannot say that. Right? In the case of Joseph Stephens, the order of acquittal was passed by the appellate court. And the parties went to the appellate court because of the reason that both the parties had to file appeal. There was part acquittal and part conviction. So both the parties, they filed their appeal before the appellate court. And the appellate court ultimately set aside the order of conviction against which the victim had filed the case before the High Court in a division. Court held that in divisional jurisdiction it was not entertainable. And in para number 10.2, the Honorable Supreme Court talks about both leave to appeal as well as direct appeal as the case may be. So we will just dispose of it, these petitions in that terms.
In the observation of Joseph Stevens, that I may
Yes,
be
yes.
directed to file an appeal.
No direction.
Because my
No,
opinion
I will
on
simply
that
say that this revision is not maintainable in view of the judgment passed by Joseph Stephens,
that
and you may avail your remedy.
of appeal. That should be there because Joseph Stevens.
You may
says
avail your
that-
remedy in terms of the observations made by the Honorable Supreme Court. We do not know whether the Honorable Supreme Division bench will take a view that a leave is required or leave is not required. But you will have your remedy as per that. And suppose you file it and then if Honorable Supreme Court if the High Court, if the Division bench takes a different view, that's a different thing. But on the face of the judgment passed by Joseph Stephens, this revision in my view is not necessary.
Anyway, it will not lie before the division bench will happen because punishment is much less. It will not lie.
No. It's a case of victim. It does not say this. It's a case of victim, and then under such circumstances, the amount of punishment is irrelevant. This is what Mr. Kashyap was saying yesterday. He was also insisting that it should be converted into appeal. Mr. Suraj, I will not convert your petition into appeal because there is a grey area, right?
Yeah.
So I will observe that you have, because Joseph Stephens para 10.4 is talking about both leave to appeal as the case may be. So it will be disposed of in that same case. I will not entertain this.
Because even the division bench, Mr. Kashyap was also there. He considered that my views at that time. And now
Concession, we are not
he
concerned.
agreed.
In the full bench also, the issue was not arising out of acquittal order passed by the appellate court,
Yeah.
isn't
Yeah.
it?
Yeah.
It is not there. So this is how it is. In the Joseph Stephens, the order of acquittal was passed by the appellate court.
If I submit that when the court put their questions whether appeal against appeal can be maintainable, then all the persons we shied away. Yeah, that is there. That is a grey area.
Grey area, so I will just leave it to the honorable division bench to decide it. But revision I cannot, on the basis of the judgment passed by Joseph Stephens, I will not entertain this revision.
We can convert it to appeal as you not.
We will not, because you may have to seek a leave to appeal.
It may be referred to.
No, why should I refer it? On the face of Joseph Stephens, I am of the view that this revision is not needed.
Yes, sir. So this case is fully covered by Stephen Joseph.
We will give the foundation fact also in the case of Joseph Stephens. The argument of this case had commenced yesterday, but a point of maintainability of the present revision application has been raised, which is required to be considered by this court. The factual background of this case is that in complaint case, which was registered as C/1 case number 2137 of 2018 under section 138 of the Engineering Instruments Act, the accused were convicted, against which an appeal was convicted by judgment dated 14/2/2020. Against the same, an appeal was filed before the Court of Sessions Judge East Sinu at Jharkhand, which was numbered as Criminal Appeal number 42 of 2020. and by the improved order passed by the Sessions Court, the criminal appeal has been allowed, and consequently the complainant, who is the victim in the complaint case, has filed the present criminal petition. The counsel for the respondent has referred to judgment passed by the Honorable Supreme Court in the case of Joseph, Stephen and others versus Sanatan Swami and others, reported in 2022 live law with the bracket SC 83, dated, the judgment dated 25th of January 2022, and he submits that in the same case, the order of acquittal was passed by the appellate court, and the victim had filed a division before the High Court. The Honorable Supreme Court framed various issues and ultimately held that the division was not maintained. He has referred to paragraph 10.2 of the aforesaid. You may all go. You will get the order. Yes. State has nothing to say?
No, sure.
The learned counsel has submitted that in view of the aforesaid factual circumstances, this petition may be held as not maintainable and be disposed of in terms of paragraph 10.2 of the counsel appearing on behalf of the petitioner has submitted that the has referred to the judgment passed by this court in Tukla Yadav versus State of Jharkhand, passed in by full bench of this court in criminal appeal within bracket SJ number 1281 of 2016, reported in 2018 SCC online JHAR 1193. And has submitted that various issues were framed by this court at paragraph number 8 and therefore you say therefore this revision will be maintainable because of full bench. Which was the issue? Do you want to refer to specifically? Which one? Issue number 8? You just tell me the issue number.
Issue number 4.
Question number 4.
This is in complaint case
Complaint. Yeah.
and has referred to issue number 4 as decided by the Honorable Full Bench by paragraph number
44.
46
40 surplus 4.
within bracket 4. And submits that the requirement of leave to appeal would arise only when the accused has been acquitted by the trial court. He has submitted that in the present case, the accused has been acquitted by the appellate court, and there is no question of any second appeal, and therefore revision is the only remedy. The learned counsel has also relied upon judgment passed by this court in CRMP number 71 of 2010 and has submitted that in view of judgment passed by the Honorable Supreme Court in the case of Joseph Stephen Supra and Mallikarjun Kodaviji, represented through legal representatives versus State of Karnataka, reported in bracket 2019 bracket 2 SCC 752. The matter was again considered with regard to the view taken by the full bench of this court in Tukla Yadav. The issue was framed in paragraph 6 of the said judgment, passed in CRMP number 71 of 2010 as follows, inverted comma. This court, after having considered the submissions advanced by learned counsel for the parties, is required to consider as to whether the judgment rendered by Honorable Apex Court in the case of Joseph Stephen, within bracket Sutra, bracket close, and Mallikarjun Kodavili Supra will be said to have prevailed over the judgment rendered by full bench of this court in Tukla Yadav Supra, and ultimately held in paragraph 13 that the law laid down by full bench of this court in the case of Tukla Yadav Supra still holds good, and therefore the petitions filed for seeking leave to file an appeal under section 378 within bracket 4 is held to be maintainable. The learned counsel submits that the state judgment was also referring to appeal to be filed by victim slash complainant where the order of acquittal has been passed by the trial court. The learned counsel has submitted that in the present case the peculiar circumstances is that the order of acquittal has been passed by the appellate, and therefore the present revision application is needed.
Yeah, this is also my suggestion that there is no provision of appeal against appeal in CRPC.
The learned, is there any bar?
There is no provision.
The learned counsel has submitted that there is no provision of any appeal against appeal under the CRPC, and in absence of such provision, the appeal would not lie before this court at all when the judgment passed by the learned trial court was already subject matter of appeal before the learned appellate court, which is impugned in the present proceedings. That's it. Get me this judgment, Chinna Swami Reddy. What is the citation of Chinna Swami Reddy? This is 1962 Supreme Court, 1788. The judgment legal. I will give further dictation in second. This judgment is required to be considered, right?
Yes.
Madam, you type it out. Yes, madam. Madam, you type it out. I will give further dictation in the second half, right? That judgment.
Yes,
will be
I will provide.
You be here, please. It's an important issue to be decided.
You know,
You see that judgment. Maybe that in that judgment it has been held. We have to see that.
I have not seen that.
That is required to be seen. Although it is 1962 judgment, but still we will see. It is prior to coming into force of this judgment, because that judgment has been considered in those 60 cases also. While going through the judgment of Joseph Stephens, I felt that it is required to be seen before I give further dictation. This one and Mr. Suraj, your matter will also be taken. You kindly call your senior also. You have seen, heard the dictation. You can see the video also if he wants to hear that.
Problem.
हाँ, वो भी second half में दोनों में. अब वो वाला जो judgment है 1962 का, उसका plea. You get. You will get the book for yourself.
Yes, sir.
For final sole item 1, criminal 56 out of 122.
against conviction under section 229 and 3054A of the Indian Penal Code, Your Lordship.
Yes, madam.
Mainly, Your Lordship, it is
Conviction by both the courts.
Your Lordship.
What is the date of incident?
25th. There is some confusion, Your Lordship. Actually, in FIR, it has been stated that
FIR, it is stated what?
that on Your Lordship, may I read the FIR?
No, you
25th,
I'm
25th
just
October,
I'm
25th.
just asking three basic facts. One is the date of incident.
25th or 26th, Your Lordship? In between
25th or
6.
25.
Most probably it is 25th evening, Your Lordship. But actually, some contradictions has there in the statement deposition of the informant.
But the incident
It should be 25th October 2010, Your Lordship.
October or
October,
September?
October 2010.
25, 10,
2010.
Continue.
And Your Lordship, FIR has been registered on 4th of November 2010, Your Lordship. And investigating officer took the charge for investigation on the same day. That is after 9 to 10 days of incident, Your Lordship. Your Lordship, first, may I need the FIR, Your Lordship?
No, you have to tell us what is what is your ground?
Grounds, Your Lordship.
What is the
Grounds, Your
purpose?
Lordship. Your Lordship. Grounds, Your
How
Lordship.
many
The
witnesses
essential witnesses, Your Lordship. 3 hearsay witnesses, 2 medical officers, and 1 IU, Your Lordship. 3 hearsay witnesses who are the relatives and friend of the informant as well as deceased, Your Lordship. Informant and deceased are related to each other, Your Lordship. Fufa and
Relative and friends of
deceased as well as informant. Because informant and deceased are also relative, Your Lordship.
uh, 3 hearsay witnesses and this witness include the informant has been examined. and
Informant has been
witness
used.
number.
PW6, Your Lordship.
PW6 is the informant. And 3 hearsay witnesses apart from informant. IU
And medical officers.
IU as PW
IU PW5, Your Lordship.
and medical doctors.
Medical doctors, PW4. PW4 is the who examined the injured informant, Your Lordship. Injury report was given by PW4, and PW7 is the doctor who conducted the postmortem of the deceased, Your Lordship.
And PW7 is postmortem.
Your Lordship.
Now, the informant is also the victim
Your Lordship, he was injured in
He was
the
injured.
accident.
in the accident. He was there.
He was traveling in the tempo, Your Lordship.
So he's the
Along
most
with his,
important witness.
along with deceased, Your Lordship.
He was the most important.
Your
witness.
Lordship. He is the most.
So you just tell us that what is the evidence of the informant. I think that will clinch the issue.
Your Lordship. As well as IU is also important, Your Lordship, because investigation has not been properly done, Your Lordship. On 4th November, after 9 to 10 days of incidents, he took charge of the investigation, Your Lordship, and he says that he seized the auto tempo from the place of occurrence, Your Lordship.
Is the incident in dispute?
Your Lordship, incident is also dispute. If the IU evidence or deposition of the IU is
The informant who is the victim of the case, he was in the vehicle in which he is also an injured person. Right? He was in the vehicle, the vehicle with which the accident had occurred. So you have to primarily see the evidence of the informant.
PW6.
Right? It is immaterial what IU has done. PW6 is the main witness. You just a discussion before the learned portfolio, and then we will see the purpose. Yes.
And he is the only witness, Your Lordship, who has stated about the rash and negligent driving, Your Lordship. No other witnesses.
They are all hearsay.
Your Lordship.
They cannot
Hearsay, हाँ, and even की
They
आयु में
cannot
आयु
say.
के जो
IU also cannot say.
चार्जशीट जो फाइल हुई उसमें भी ये चीज फाइंडिंग नहीं आया है
IU
rash
also
and
cannot say.
Your Lordship, PW6 डिपोजिशन ऑफ PW6 घटना 2-2.5 साल पहले की शाम की है। यहाँ 13 नवंबर 2013 को ये दे रहे हैं डिपोजिशन Your Lordship आफ्टर 3 years of the incidents and saying that घटना 2-2.5 साल पहले की शाम की है। मैं टेम्पो से रेड़मा में बैठकर कुंदरी जा रहा था। मेरे साथ फूफा बुधन राम भी टेम्पो में सवार थे। कुंदरी पुल के पास पहुंचा तो टेम्पो पलट गया। यहाँ पे जो कुंदरी बोल रहे हैं लॉर्डशिप जा रहा था, FIR में कहीं और जा रहे हैं बोले थे। तो कुंदरी इज द प्लेस ऑफ अकरेंस। कुंदरी पुल
के पास।
हाँ पहुंचा तो टेम्पो पलट गया।
नहीं, कहाँ जा रहे हैं?
कुंदरी ही जा रहे हैं लिखे से। मैं टेम्पो में रेड़मा से बैठकर कुंदरी जा रहा था और रीस्टेटमेंट में और FIR में वो बांसडी करके
But the place of occurrence is
कुंदरी
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 Place of occurrence is also not in district.
कुंदरी पुल बस
Also not in district.
कुंदरी पुल के पास पहुंचा तो टेम्पो पलट गया। मैं बेहोश हो गया। मुझे सदर अस्पताल में होश आया तो डॉक्टर ने बताया कि मेरे फूफा की मृत्यु हो गई है। टेम्पो में मेरे फूफा तथा चालक के अलावा और कोई नहीं था। Lordship, he has improved his statement. Earlier, he has stated that other passengers were also there in the tempo, and they also got injured. Para 2. चालक टेम्पो काफी तेजी से चला रहा था। मैं मना भी किया था कि तेजी से मत चलाओ, लेकिन नहीं माना। लापरवाही से टेम्पो पलट गया। Para 3. मैंने ही थाना में सूचना दिया था। यही वह फर्द बयान है जिसे मेरे कहने पर लिखा गया था, जिसको पढ़कर अपना हस्ताक्षर बनाया था। मैं पहचानता हूँ, इसे प्रदर्श 2/1 अंकित किया जाए। यहाँ ये एडमिट कर रहे हैं कि मेरे फर्द बयान पे है और हम पढ़ के इसको साइन किए हैं, जो भी उस पर लिखा हुआ है। शकूर मियाँ हाँ न्यायालय में उपस्थित है। मैं पहचानता हूँ, यही वह टेम्पो चला रहा था। टेम्पो के नंबर अंकित नहीं था, वह नया टेम्पो। इसमें एक और चीज मेंशन करना चाहेंगे लॉर्डशिप, FIR जस्ट नेक्स्ट डे ऑफ द इंसिडेंट फर्द बयान हुआ है, उसी दिन रात में हुआ है और उसमें वो पिटिशनर का नाम, पेरेंटेज और एड्रेस के साथ FIR रजिस्टर्ड हुआ है। They were knowing everything about the driver.
Is there any reason to falsely indicate the driver?
Lordship,
Is there any previous enmity between the driver and the informant?
ड्राइवर और इन्फॉर्मेंट का तो एनिमिटी नहीं है लॉर्डशिप, लेकिन इनका रिलेटिव कोई है जो चौकीदार है, उसका था कि वो उस लोग को इंस्टिगेट किया था, ऐसा कुछ था। और ये लॉर्डशिप
You just see the cross examination of
हाँ।
PW6.
हाँ।
That will serve the purpose. And we read the cross.
और एनिमिटी में लॉर्डशिप ये भी
You just read the cross examination.
क्रॉस एग्जाम। मैं ड्राइवर को पहले से नहीं जानता था। टेम्पो में चढ़ने से पहले फूफा ने ड्राइवर का नाम एवं पिता के नाम पूछा था, मैंने सुना था। लॉर्डशिप, इसमें रेसिडेंस भी वहाँ दिया गया है। टेम्पो में लॉर्डशिप, इट इज नॉट बिलीवेबल बाय एनी पर्सन ऑफ रीजनेबल प्रूडेंस कि ऑटो में बैठेंगे तो ऑटो का ड्राइवर का नाम और उसका पिता का नाम पूछेंगे। टेम्पो पर शाम 6:30 बजे रेड़मा में सवार हुआ था। यहाँ पे ये कह रहे हैं लॉर्डशिप शाम 6:30 बजे सवार हुआ था। FIR में कुछ और है लॉर्डशिप। मुझे अस्पताल लाने वाला का नाम नहीं बता सकता हूँ, मैं बेहोश था। मुझे उसी रात को होश आ गया। होश होने पर मैंने घर के किसी सदस्य को नहीं पाया था। ये वहीं पर बेहोश हो गए थे, प्लेस ऑफ अकरेंस पे ही बेहोश हो गए। टेम्पो में और कितने सवारी थे याद नहीं है। सीट भरा था। हम लोग बांसडी जा रहे थे। डाल्टनगंज से दूरी नहीं बता सकता हूँ। सीट भरा था यहाँ पे बोल रहे हैं। कितने दूर चलने पर एवं कितने देर में दुर्घटना हुई नहीं बता सकता हूँ। मतलब टाइम ऑफ अकरेंस वो नहीं बता सकते। दुर्घटना के समय अंधेरा था या उजाला था ये भी नहीं बता सकता है। रात में मुझे ठीक से दिखाई नहीं देता है। पुलिस मेरा बयान सुबह ली थी। पुलिस मेरा बयान सुबह ली थी। मैंने बयान में बताया था कि टेम्पो में सिर्फ मैं और मेरे फूफा सवार थे, जबकि बयान में ऐसा नहीं है लॉर्डशिप। वो बोल रहे हैं अदर पैसेंजर भी सवार थे जो फर्ज बयान ली थी और वो लोग भी इंजर्ड हुए थे, ऐसा FIR में लिखा हुआ है।
Did you confront him with the FIR?
Your Lordship,
Did you confront him with the FIR?
Your Lordship, I am just trying to show that he is the sole witness who has stated about rash and negligent driving, Your Lordship, which is one of the essential ingredient to attract section 279 and 304A of the Indian Penal Code, Your Lordship. And Your Lordship, if we rely on the testimony of a sole eyewitness or interested witness, Your Lordship, it must be reliable, trustworthy, Your Lordship, and must be consistent, Your Lordship. Your Lordship, पारा 9 कितने दूर चलने पर हो गया था? हाँ, रात में मुझे ठीक से दिखाई नहीं देता। फिर पुलिस मेरा बयान सुबह ली थी। मैंने बयान में बताया था कि टेम्पो में सिर्फ मैं एवं मेरे फूफा सवार थे। उस समय अन्य गाड़ियां भी चल रही थी। घटना के दिन के बाद मैं आज न्यायालय में ड्राइवर को देख रहा हूँ। 3 साल बाद देख रहे हैं ड्राइवर को, घटना के दिन के बाद से। थाना में बुलाकर पुलिस ने घटना के 3-4 दिन बाद लेस्लीगंज थाना में पूछताछ किया था। ये लॉर्डशिप इसमें भी है 4 नवंबर को जब वो इन्वेस्टिगेशन का चार्ज लिए हैं तो घटना के 3-4 दिन बाद इनको कहाँ से बुला के थाना में पूछेंगे? ऐसी बात नहीं है कि हम टेम्पो पर सवार नहीं थे। ड्राइवर तेजी से गाड़ी नहीं चला रहा था। ये तो सजेशन को डिनाई किया लॉर्डशिप। इसमें लॉर्डशिप टाइम ऑफ अकरेंस का डिस्प्यूट बहुत जगह है। यहाँ के IO बोलते हैं जब रीस्टेटमेंट लिए थे तो सुबह 7 बजे का एक्सीडेंट का टाइम है, 25/10/2010 को 5:20 में चले थे। और IO का स्टेटमेंट इसीलिए डिपोजिशन इसलिए ज़रूरी है लॉर्डशिप, क्योंकि IO का डिपोजिशन हम पढ़ देते हैं PW5 का ही लॉर्डशिप।
So you just complete your argument with respect to PW6.
PW6 के रेस्पेक्ट में यही आर्गुमेंट है ये लॉर्डशिप। अगर FIR देखा जाए ये लॉर्डशिप,
We will not see that.
ये लॉर्डशिप हमारा बस इसमें यही दिखाना है कि अगर हम सोल टेस्टिमनी पर रिलाई करते हैं तो इट मस्ट बी रिलायबल टेस्ट। इस पर जजमेंट भी है लॉर्डशिप। हाउएवर आई कुड नॉट ब्रिंग टुडे लॉर्डशिप ड्यू टू paucity of time lordship, but there are several judgments that if we rely on the testimony of the either sole eyewitness or interested witness in lordship, it must be reliable, trustworthy and must be consistent in lordship. कभी कुछ बोल रहे कभी कुछ बोल रहे हैं और corroborate भी नहीं हो रहा है बाकी सबसे। ये जो बोलते
So
हैं
you are saying that there is contradictions.
contradictions in lordship। contradictions को पॉइंट आउट तो FIR से ही किया जा सकता है लॉर्डशिप। और उनका रीस्टेटमेंट जो IO बोल रहे हैं, IO जो यहाँ बोल रहे हैं डिपोजिशन से किया जा सकता है, इसलिए IO का PW5 का पढ़ देते हैं। दिनांक 4 नवंबर 2010 को मैं लेस्ली थाना में SI के पद पर था। उसी दिन लेस्लीगंज कांड संख्या सो का अनुसंधान का भार थाना प्रभारी विनोद पासवान से लिया। 4 नवंबर 2010 को एक्सीडेंट टुक प्लेस ऑन 5 अक्टूबर 2010। वादी के फर्द बयान में दृष्टांकन थाना प्रभारी विनोद पासवान का है एवं उनका हस्ताक्षर मैं पहचानता हूं, इसे प्रदर्श 1600 अंकित किया जाता है। इस औपचारिक प्राथमिकी पर 2 जगह विनोद पासवान थाना प्रभारी का हस्ताक्षर है, मैं पहचानता हूं, इसे प्रदर्श 3 एवं 3/1 अंकित किया जाता है। अनुसंधान का भार लेने के बाद घटना स्थल के लिए 4 नवंबर 2010 को 11:30 बजे दिन में प्रस्थान किया। इस कांड का घटना स्थल लेस्लीगंज थाना अंतर्गत पलामू पाकी पक्की सड़क कुंदरा पुल है जो कुर्दी के पास है। पहले आधा किलोमीटर पश्चिम है। घटना स्थल के उत्तर में पड़ती जमीन है। नहर बांध, परती जमीन और बांध पूरब में पक्की सड़क, पश्चिम में पक्की सड़क है। साक्षी अंबिका राम, विनोद राम, वीरेंद्र राम का बयान दिया, जिन्होंने घटना की को सही बताया। बाकी का पुनर्बयान लिया, उसने भी वादी का पुनर्बयान लिया। उसने अपने बयान में बताया कि 25/10/2010 को 5:30 बजे शाम में फूफा बुधन राम के साथ अपनी बहन के पास चौर बांसडी जा रहे थे। 7 बजे सुबह टेम्पो पलटी कर गया। लॉर्डशिप यहाँ देखा जाए 5:30 बजे जा रहे थे, और वादी का पुनर्बयान जो लिए हैं लॉर्डशिप 4 नवंबर के बाद लिए होंगे, और वादी कह रहा है कि घटना के 2-3 बाद पुलिस पूछताछ हमसे की थी। एवं वादी ने प्राथमिकी का पूर्ण समर्थन किया। मृतक यहाँ पे लॉर्डशिप जो PW1 जो अंबिका राम और विनोद कुमार, ये लोग का जो PW1 PW3 का बयान बोल रहे हैं, ये भी बोल रहे हैं कि 4 नवंबर के बाद लिए। ये लोग भी अपना बयान में डिपोजिशन में बोला है कि 1-2 दिन बाद घटना के बयान लिया गया था। सवारी में प्राथमिकी का पूर्ण समर्थन किया। वादी ने प्राथमिकी का पूर्ण समर्थन किया। मृतक बुधन राम को पोस्टमार्टम रिपोर्ट प्राप्त किया। महेंद्र पासवान वादी का जख्म प्रतिवेदन प्राप्त किया। इस कांड के अभियुक्त चालक सकूर मियां व सकूर को 30 नवंबर 2010 को जमानत पर मुक्त किया। दुर्घटनाग्रस्त टेम्पो नंबर सो एंड सो के मालिक सह चालक द्वारा कागजात प्रस्तुत किया गया। MVI को जांच हेतु, यहाँ पे गाड़ी का नंबर बता रहे हैं दोषी, MVI को जांच हेतु प्रतिवेदन में था। 3/12/2010 को प्राप्त हुआ। 11/12/2010 को न्यायालय के आदेश से टेम्पो मुक्त किया। वरीय पदाधिकारी के निर्देशानुसार सकूर मियां अलिया सकूर जो कि के विरुद्ध आरोप पत्र संख्या सो दिनांक सो धारा सो में समर्पित किया।
When he was
released on bail, your lordship,
that date he has given.
हाँ
Same day.
सेम डे नहीं, नवंबर में चार्ज लिया तो सेम डे कहाँ से रिलीज होगा? FIR पे नहीं, 30 नवंबर यहाँ पे डेट है सर। चालक सकूर मियां के 30 नवंबर 2010 को जमानत पर किया और गाड़ी रिलीज हुआ है 11 दिसंबर 2010 को। लॉर्डशिप वरीय पदाधिकारी के निर्देशानुसार सकूर मियां के विरुद्ध आरोप पत्र हो गया। अनुसंधान के क्रम में अभियुक्त से भेंट नहीं हुआ था। लास्टली अपने डिपोजिशन में बोलते हैं कि अभियुक्त से मुलाकात नहीं हुआ था पूरे अनुसंधान के दरमियान में। अब नीचे क्रॉस हम पढ़ दे रहे हैं। क्रॉस में है कि वादी महेंद्र पासवान ने थाना के में मुलाकात हुई थी। मैंने जख्म प्रतिवेदन के लिए उन्हें कागज बनाकर दिया था। यहाँ पे देखा जाए लॉर्डशिप, एक वादी से जब भी मुलाकात हुआ होगा 4 नवंबर के बाद हुआ होगा। इनका जख्म प्रतिवेदन पहले का है लॉर्डशिप। इनका मेडिकल ऑफिसर जो बता रहे हैं, उन्होंने बोला है कि उसी दिन रात में 10:45 बजे हम उनका एग्जामिन किए थे इन्फॉर्मेंट को, मतलब 25/10/2010 को रात के 10:45 बजे। ये लॉर्डशिप ये कह रहे हैं कि हम जख्म प्रतिवेदन इनको बना के दिए थे थाना में। जब आए वादी थाना में जब आए तब हम इनको जख्म प्रतिवेदन के लिए आवेदन बना के दे दिया जाता है। पुलिस आवेदन बना के देती है तो मेडिकल ऑफिसर जख्म प्रतिवेदन देते हैं। तो जख्म प्रतिवेदन का डेट जो है लॉर्डशिप पहले का है।
Naturally, it has to be prior to that. What is this? They will file an application to obtain the medical report. They have obtained the medical report. Medical report was prepared on the same day at 10 o'clock. It is not your case that the incident did not happen, nor it is your case that he was not there in the vehicle. It is not your case. You have not examined the victim by saying that you were not present or you are not injured. That is not your case.
लेकिन उसमें तो वो मेडिकल
No,
रिपोर्ट
there is
में
no
तो
such
आया कि
cross-examination of the victim on this point. You should have confronted him that he was not there in the vehicle. He has falsely implicated you. That is not your case. You cannot have a new case made out.
लॉर्डशिप इसमें आगे थोड़ा सा देखते हैं। पैरा 6 में बोलते हैं क्रॉस में, मैंने अभियुक्त से मिलने का प्रयास किया था, ऐसा जिक्र डायरी में नहीं किया है। गाड़ी मुक्त करने समय कागजात अभियुक्त का पुत्र लेकर आया था, उन्हें ही गाड़ी सौंपा था। गाड़ी का प्राप्ति रसीद है जिसमें सकूर अंसारी का हस्ताक्षर है, पहचानता हूँ। हस्ताक्षर को प्रदेश ए अंकित किया जाए। कहते हैं इंटायर इन्वेस्टिगेशन में हम सकूर मियाँ से नहीं मिले हैं। गाड़ी भी रिसीव करने उनका पुत्र आया था और प्राप्ति रसीद देखा जाए लॉर्डशिप, उसमें पिटिशनर का सिग्नेचर है और पिटिशनर का सिग्नेचर को पहचानते हैं।
These kind of contradictions, incident is not in dispute. Injured person in the vehicle is not in
Your
dispute.
Lordship, but rash and negligent driving is in dispute, Your Lordship. यहाँ यही है लॉर्डशिप कि जस्ट एक्सीडेंट हुआ है, इसमें रैश नेग्लिजेंट ड्राइविंग नहीं था, जस्ट एक्सीडेंट हुआ है, पलटा है, ठीक है वो मरा है, लेकिन इसको रैश एंड नेग्लिजेंट ड्राइविंग नहीं माना जा सकता इतना कि मैक्सिमम पनिशमेंट अवॉर्ड कर दिया जाए। Petitioner. Yes, Your Lordship, 2 years is the maximum punishment awarded, Your Lordship, to the petitioner, Your Lordship.
He has been convicted under section 304A.
Your Lordship. महेंद्र ने बताया था कि दुर्घटना के समय टेम्पो में 2-3 व्यक्ति थे, ड्राइवर, सूचक और मृतक थे। ऐसी बात नहीं है कि मैंने त्रुटिपूर्ण अनुसंधान करके गलत आरोप किए हैं। यहाँ हमारा यही सबमिशन है, ये लॉर्डशिप की रैश एंड नेग्लिजेंट ड्राइविंग का कहीं भी नहीं आया है, एक्सेप्ट दिस इन्फॉर्मेंट ए लॉर्डशिप हु इज इंटरेस्टेड विटनेस ए लॉर्डशिप। जहाँ तक रैश एंड नेग्लिजेंट का है लॉर्डशिप,
Informant is interested witness. From where do you get this?
ये लॉर्डशिप ही इज द
Show me from some evidence that he is an interested witness. Is there any cross-examination that he is an interested witness? From where are you seeing that he is an
उनके
interested
फूफा थे डिसीज लॉर्डशिप।
So what? Interested means what? He was
इंटरेस्टेड लॉर्डशिप कंपनसेशन का केस फाइल होता है, जब तक अगर एफआईआर में रैश एंड नेग्लिजेंट ड्राइविंग नहीं लिखा रहेगा लॉर्डशिप, कंपनसेशन नहीं मिलता है लॉर्डशिप। तो अगर सिर्फ एफआईआर में लिख दिया गया रैश एंड नेग्लिजेंट ड्राइविंग है और उसको सपोर्ट करने के लिए सिर्फ इन्फॉर्मेंट बोल दिया गया, व्हाई द अदर पैसेंजर्स हु वर ट्रैवलिंग इन द ऑटो लॉर्डशिप, व्हाई दे वर नॉट एग्जामिन्ड लॉर्डशिप? इतने दिन के बाद एफआईआर रजिस्टर्ड क्यों किया गया लॉर्डशिप? 9-10 दिन बाद। ये सब है कि बियॉन्ड रीजनेबल डाउट नहीं प्रूफ होता है लॉर्डशिप। जो भी है घटना है, टाइम ऑफ अकरेंस का हर जगह, अगर हम इस पे जजमेंट हम दे देंगे लॉर्डशिप कि अगर
दे देंगे, जो करना है आपको
हम दे देंगे, आज सेकंड हाफ में दे देंगे लॉर्डशिप, नहीं निकल पाए
I am hearing your case and you should have come to
लॉर्डशिप।
Yesterday also
मोबाइल
you were-
पहला केस था ये लॉर्डशिप, हम रात में देखे, लिए मोबाइल में भी डाउनलोड किया, वो मोबाइल भी छूट गया ये लॉर्डशिप।
passed over twice it was passed over yesterday.
कल ही तो एलसीआर तो कल ही देखे है लॉर्डशिप।
That is all.
एक साल कस्टडी हो चुका है ये लॉर्डशिप, और ऐसा
1 year custody.
ये लॉर्डशिप,
From where did you get this? He was released on bail on 30/11/2010.
ये लॉर्डशिप उसके बाद फिर अपील के बाद फिर कस्टडी में चले गए थे ना। अपील का इनको पता नहीं था कि अपील कब, अपील का ये नहीं हुआ तो फिर कस्टडी में चले गए थे, फिर हाई कोर्ट का ऑर्डर हुआ तब वो जाके रिलीज हुए थे।
What is the period of custody?
6 जनवरी 2022 को कस्टडी में गए थे और फिर हाई कोर्ट का ऑर्डर हुआ था।
Tell us a date.
ऑर्डर ऑर्डर रिकॉर्ड नहीं हो रहा है। आइए फाइल किए तो दोबारा तब जाके हुई। 6 जनवरी 2022 से कस्टडी में दोबारा से
15/6/22.
15/6/22 का एक ऑर्डर,
लेकिन उसके बाद उस दिन
I am not inclined to enlarge the petition on bail. On
ये
15/6.
लॉर्डशिप
रिन्यू
उसके
आफ्टर
बाद
6
दोबारा
months.
फिर फाइल किए थे लॉर्डशिप, तब हुआ था।
On 23/12. Any other previous conviction?
नो ये लॉर्डशिप, नो criminal antecedent. Yes.
But while releasing the tempo in question, a report was called for from the MVI, and that report shows that the tempo was in a fit condition, ब्रेक और ये सब चीज ठीक था, उलटने के बाद भी कुछ चोट आया है। Therefore, what I want to
You see, there is no question of disputing the incident.
yes,
There is no question of disputing that person has died.
yes,
There is no question of disputing that there is a victim. Now you tell us that this person has remained in custody for almost a year, but no fine has been imposed. The case is of the year 2000. How many years have passed by now? So we are thinking of modifying the sentence.
my lords, it
The
is
period undergone and some fine.
that is
Some fine we can impose because no fine has been imposed by the guy. No fine is imposed to the accused. Trial court has not imposed
1,000
any.
up to 1,000.
That should be sufficient. No previous conviction, I take your words, I do not know.
ये लॉर्डशिप, ये लॉर्डशिप।
it's may
Yes, if you want to take leave. Yes. That's it. For the learned counsel for the parties. This criminal remission has been preferred against judgment dated 12/7/2018 passed by learned edition sessions judge Roman 3 Badminton Palami in criminal appeal number 74 of 2018. Thereby, the appeal filed by the petitioner has been dismissed and the learned sessions judge learned edition sessions judge has confirmed the judgment of conviction and order of sentence dated 25/9/2014 passed by learned judicial magistrate first class Darlington in connection with GR case number 2300 of 2010 corresponding to trial number 847 of 2014 arising out of Leslie-Ganj PS case number 79 of 2010, by which the petitioner was held guilty for offence punishable under section 279, 337 and 304 capital of Indian Penal Code and has been sentenced with substantive punishment to undergo rigorous imprisonment for 3 months for offence under section 279, 3 months for offence under section 377 and 2 years for offence under section 304 capital of IPC. However, no fine has been imposed and all taken place on 25/26 of October 2010, and the FIR was registered only on 4/11/2010 by the informant who is said to be the injured witness, who is said to be the injured person in the accident and was a passenger in the vehicle. The learned counsel has submitted that there is no explanation for delay in filing the FIR.
Registering them.
In registering the FIR, which was registered on 4/11/2010. Yes, she has submitted that altogether 7 witnesses were examined, and 3 of them were hearsay witnesses, and the material witness are PW6, the informant / injured witness, and the investigating officer who was examined as and the investigating officer of the case, PW5. The learned counsel further submits that the injured witness was examined by the doctor, PW4, and the postmortem was conducted by the doctor, PW7. She submits that the sole eyewitness in the present case is PW6, and in order to sustain the conviction, the evidence of PW6 should be not only reliable but also trustworthy.
Must be consistent.
Madam, please don't insert words like this. You please. And his evidence must be consistent. She submits that the PW6 has stated that here that the police had taken his statement after 2 or 3 days. The learned counsel submits that of the incident, the learned counsel submits that when the FIR was registered later on, then under such circumstances there was no occasion to take his statement 2 or 3 days after the incident. She has also submitted that there is contradiction in connection with the time of incident also, in as much as the FIR reflects that time of incident was around 5:10.
टाइम ऑफ इंसिडेंस बोला नहीं गया लॉर्डशिप 5:10 में बोलते हैं हम लोग टेम्पो में सवार हुए थे.
As per the FIR, it has been stated that the deceased victim as well as PW6 had boarded the tempo around 5 p.m. But the time of accident has been said to be around 6:30 p.m. in the evidence of PW6. The learned counsel has submitted that the basic element of rash and negligent driving is completely missing in the present case, and therefore the order of conviction passed by the learned trial court and confirmed by the learned appellate court is perverse, which calls for interference by this court. She has further submitted that as per the evidence of the investigating officer, the petitioner was released on bail on 30/11/2010. The vehicle was released on 11/12/2010, and during the pendency of the present revision application, the petitioner has remained in custody during the period from 6/1/2022 to 23/12/2022. And when a bail order was passed by this court in favor of the petitioner, a few days must have been taken by the petitioner to furnish the bail bonds. She submits that the custody of the petitioner is in connection with the present case is more than minor, and there is no previous conviction of the petitioner. She has also submitted that the petitioner has also suffered long drawn proceedings which commenced right from the year 2010. Considering the nature of the incident, in case this court is not inclined to set aside the order of conviction, the sentence will be modified to the period already undergone. That is it.
बस लॉर्डशिप एफआईआर में जो टाइम कहीं मेंशन नहीं है, रीस्टेटमेंट में 5:30 वाला आया, उसको खाली बीच में हम डिस्टर्ब नहीं किए.
5:30.
हाँ, वो रीस्टेटमेंट जो
She has submitted that in the FIR. The exact time of the incident has not been mentioned, but in the restatement, the time of the incident was disclosed
7
by
AM
the-
7 AM सुबह ये लॉर्डशिप बोल रहे हैं. आयु जो यहाँ डिपोजिशन दिए हैं 7 बजे सुबह बोल रहे हैं. 5:30 मिनट ऑटो में चढ़े थे, 7 बजे सुबह हुआ है. 5:30 25 अक्टूबर.
The learned counsel has submitted. सुबह कहाँ लिखे हैं?
ये लॉर्डशिप डिपोजिशन में जो आयु का आया है, पेज नंबर 2 में डिपोजिशन जो है 1 2 3 चौथा लाइन में है लॉर्डशिप. वादी का पुनर्बयान लिया गया. बयान में बताया कि 25/10/2010 को 5:30 बजे शाम में फूफा बुधन राम के साथ अपनी बहन के पास जा रहे थे. 7 बजे सुबह टेम्पो पलटी कर गया.
The learned counsel has submitted that the IU has stated that the petitioner had boarded the tempo with the deceased victim at 5:30 p.m. But the incident had taken place at 7 a.m. in the morning. After hearing the learned counsel for the state has opposed the prayer and has submitted that both the courts have returned consistent findings, and there is no scope for appreciation of evidence. Reappreciation of evidence by this court in judicial jurisdiction, and therefore the improved judgments do not call for any interference. वादी का पुनः बयान में ऐसा नहीं.
ये लॉर्डशिप
वादी का पुनः बयान में ऐसा नहीं. सुबह नहीं लिखा.
लिखा हुआ नहीं है वहाँ, लेकिन आइयो जो बोले हम
नहीं, आइयो
केस
तो
डायरी
बोले
को.
हैं।
हाँ,
केस डायरी में नहीं.
अच्छा, केस डायरी को क्योंकि रिलाई नहीं किया जाता इसमें एविडेंस के
नहीं
बाद,
किया
इसलिए
जाता,
नहीं. हाँ, इसलिए हम नहीं देखे केस डायरी को. केस डायरी मेरे पास है भी नहीं है.
However, so far as modification of sentence is concerned, he has nothing to say, and it is for the court to pass an appropriate order. What is the age of the petitioner?
36 years 2022 में लॉर्डशिप लिखे.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that as per the prosecution case, on 26/10/2010. The informant had boarded the tempo along with his uncle, and when it reached near the bridge, the tempo lost its control and turned turtle. And in that incident, the incident had taken place due to rash and negligent driving of the petitioner, and his uncle sustained serious injuries. When he was brought to the hospital, he was found dead. It was also alleged that the informant and other passengers had also sustained injuries. The FIR was registered as Leslie case number 79 of 2010, dated 4/11/2010, under section 279, 337, 338, 304 IPC against the petitioner. Charge sheet was submitted and community was taken under section 279, 337, and 304 IPC. The substance of accusation was explained and the petitioner pleaded not guilty. His statement was recorded under section 313 after the evidence of the prosecution, and he claimed to be innocent. Altogether, 7 witnesses were examined before the learned trial court. The most important witness, although there are all the witnesses have supported the prosecution case. So far as PW4 is concerned, he had examined the informant. He has stated that he had examined the informant on 25/10/2010 at around 10:45 p.m. and following injuries were found, and the injuries were found, and the nature of injuries was simple and caused by hard and blunt object. The injury report was exhibited as Exhibit 1, and he had stated that such type of injury could be caused by motor accident. The witness was also examined. The other doctor, namely PW7, was examined, who has conducted the postmortem. And recorded the antemortem injuries as follows. And the cause of death was shown to be shock and hemorrhage arising out of the aforesaid injuries. The injury, the postmortem was marked as Exhibit 4, and he was duly cross-examined. And he stated in his cross-examination that such type of injury may be caused by falling from high place on hard surface. So far as the informant is concerned, he has been examined as PW6, who is one of the victims of the occurrence, as he is an injured witness. He has fully supported the case of the prosecution, and he has mentioned about the occurrence, and he has also stated that the tempo was being driven rashly and negligently, and he had warned the driver also to drive slowly. but the driver did not take care and the tempo turned turtle. His FIR was, he gave information to the police and his FIR was marked as incident. He has been cross-examined, and during cross-examination he has stated that he did not know the accused from prior to the offence, but on a question has said that the details of the driver was asked by his uncle before the offence. He admitted that there was dark at the time of occurrence and that his eyewitness is not proper in dark. He has admitted that after occurrence he had seen the accused for the first time in the court. The learned court below, after considering the evidences, the learned trial court, after considering the evidences, has recorded a finding that the IU of the case was also examined. He had also supported the case, but during his examination, he has stated that the incident had taken place at 7 a.m. in the morning, and he has stated that he was told by the informant that as per the Fodbayan, the incident had taken place at 7 a.m. in the morning, and the informant and his Pupa had wounded the tempo at 5:30 in the evening. Admittedly, the IU had taken charge of the investigation after the FIR was registered on 4th, and the most important witness in the present case is the informant himself. He has fully supported the incident with the time, place, and the manner of occurrence, and he has been cross-examined, and there is no cross-examination of the informant in connection with the time of the incident. This court is of the considered view that the learned trial court has the learned trial court, after considering the evidences and recorded a finding in paragraph 15 as under, and held the petition guilty of offence under the quoted sections. And impose the punishment as a coercive. So far as the appellate court is concerned, the appellate court has also considered the materials on record and gave concurrent findings. considering the findings of the learned appellate court is recorded in paragraph 16, which is quoted as under. This court finds that there are contrary findings recorded by the learned by both the courts. The contradictions which have been pointed out by the petitioner are not material. The incident is not in dispute. The informant of the case has been examined and thoroughly cross-examined. This court finds that the evidence of the informant, who is also an injured witness, is consistent and reliable and trustworthy, which has also been relied upon by both the courts. This court does not find any reason to differ with the findings recorded by the learned trial court and upheld by the learned appellate court. No material irregularity or perversity has been pointed out by the learned counsel for the petitioner to calling for any interference in judicial jurisdiction. I'll give one judgment, I'll cite one judgment.
Lordship,
And
one judgment.
Please hold on. And accordingly, so far as the conviction is concerned, this court does not call for the same does not call for any difference. However, so far as the sentence is concerned, this court is of the view that the petitioner, as submitted by the counsel, has already remained in custody for more than a year, and the petitioner has been facing the criminal case since 2010. And as per the records, the present offence is his first offence. This court is of the view that the ends of justice would be served if the period of sentence of the petition is modified. Accordingly, the period of sentence of the petition is modified to the extent of period already undergone by the petitioner in custody, with a fine of rupees 25,000. The entire fine amount is directed to be credited to the informant of the case after due
Lordship, if
the
possible.
fine amount being deposited by the petitioner before the trial court within the period of 2 months from today. If the fine amount is not deposited within the stipulated time, the petitioner will serve the sentence already imposed by the learned trial court and upheld by the learned appellate court. This petition is accordingly modified. This disposed of with the requisite modifications.
If possible, it's fine to come with the
Item 2, Criminal Division 424 of 2022.
this
did
is
not start with one argument yesterday. Kindly.
this is the same issue, Your Lordship,
Same issue.
which Your Lordship have heard in the first half
Yes,
that
yes.
regarding
It's the
the
same issue, no? You come in the second half. I pass an order along with this. You are the victim.
yes. I am the victim.
Complainant.
Complainant.
Acquitted by the active court.
Complainant first there was a conviction against that appeal was filed, appeal there was acquittal against that their division.
Okay. I will just pass this order in the second half. You have heard it in the first half also. I have partly dictated the order. Recorded the submission of both the parties. I give my finding in the second half. If it is held maintainable, then only you will be heard. Otherwise, you have to file your appeal or leave to appeal as the case may be. Right?
नहीं ठीक है.
Item 3, Criminal Gen 1092 of 2022.
Where is the petitioner? She wanted to withdraw this case today. Yesterday, what's the name of this? She wanted to withdraw this case today. Shivani. Wait, the name flashed. Otherwise, I'll dismiss the case for default.
I'm appearing on behalf of the state.
Please call
Madam,
me
madam.
as CBI matter has
Madam,
to be appearing. Yesterday they said that this case has come
Madam.
in front of us. Today they are not appearing.
होना चाहिए था.
Might have become infructuous. We do not know. Might have become. What kind of submission is this? They have come against which order?
Pass on.
For us, Item 4, Criminal Gen 298 of 2022.
Was earlier also heard is also. The revision has been filed against the acquittal
Oh, yesterday you had filed. Revision has been filed against acquittal.
by the trial court, magistrate court.
This is not material.
Yes, Your Lordship. Yeah, yes.
So you withdraw?
I have one judgment of Chhattisgarh High Court, Your Lordship, before the consideration of.
No, this revision is not maintainable. We will not enter into.
Yes, Your Lordship, this is not maintainable. But against this SLP, a special leave have to file an appeal before the session court against the acquittal under section
No,
138.
against acquittal you have to move the high court. Against acquittal you have a remedy before the high court.
High Court.
Please, you see, there are you don't commit another mistake. This is not maintainable.
But-
See, if the person is acquitted
Yes.
by the trial court, then the appeal will lie before the high court after leave. No,
After-
as a matter of right.
Matter of right. Yes, Your
So
Lordship.
you
But
just find it out from your seniors, but this revision is not.
it can be converted into that.
No, we will not.
So then liberty
You
may
do whatever.
be granted to file
Yes.
as per the Quran.
Criminal revision number 298 of.
But Your Lordship,
2022.
in 138, acquittal under section 138 NI Act, Your Lordship. Under that, victim is the complainant, and for that, SLP had to special leave have to be taken from the High Court. Thereafter, appeal.
I'm not here to advise you. You do whatever you want to, but this revision is not,
Must.
it cannot be entertained, right?
Appeal has to be filed, Your Lordship, in
We
view
will
of,
file whatever.
in view of 378(4).
378(4).
Yes.
Anyways, criminal revision number 298 of 2022. This revision has been filed against the judgment of acquittal passed by the learned Court of Judicial Magistrate Palamur. Right. Judgment dated 13/12/2021 by the learned Judicial Magistrate First Class in complaint case number 1930 of 2017/TR number 803 of 2021, whereby the opposite party number 2 has been acquitted for alleged offence under section 138 of Negotiation Instrument Act. The learned counsel for the opposite party has submitted that the present revision is not maintainable, and the petitioner, being the complainant/victim,
Yes.
has a remedy under the provisions of section 378,
Subsection 2.
subsection 4, has a remedy of appeal under the provisions of CRPC. She has referred to section 378 within bracket 4 and also proviso to section 372.
But it has been held that 378(4) will be applicable.
She has referred to section 378 within bracket 4 of CRPC. And this counsel for the petitioner, considering the approaches, you want to withdraw?
Withdraw with liberty to.
Well, and this counsel for the petitioner seeks permission to withdraw this petition with the liberty to avail this remedy as per law.
Your Ladyship, one problem will appear in this case because under the provision of 378(4), 60 days is the
No, that you
limitation.
will have to explain by filing a limitation. The impugned order in the present case has been passed on 13/12/2021, and the present case has been filed on 31/3/2020. This I am recording it in law.
Yes, sir.
The office has also pointed out that the present case is not maintainable in view of order dated 19/9/2018 passed in criminal appeal within bracket SJ that goes 1281 of 2016. Considering the efforts of submissions in the office, this revision is not maintainable and accordingly it is dismissed. However, liberty is reserved with the petitioner to avail his remedy.
Much
You want to just the record and announce to general and proceed with the record.
Item 5, Criminal 441 of 2022.
Perhaps last date the order has been passed. Perhaps wrongly listed, my lord.
23 हो गया बिल्कुल से। 22 criminal revision number 441 of 2022. This matter has been listed as the instance of the office. It has been pointed out that in order dated 17 February 2024, the case number has been wrongly mentioned as criminal revision number 441 of 2023 instead of criminal revision number 441 of 2022. आप हैं?
Huh. Last time, Lord, unluckily I missed it. In fact, Lord, he has to surrender. But in fact, Lord, he is on deathbed. Therefore, he is 75 years old. Therefore, he is not in deathbed. But only doctor has declared him medically unfit in all respect, and therefore he is not surrendering. Lord, I have to file another exemption petition in that case for after seeking instruction. It is similarly not at all a case of 498, even then the court has convicted.
Considering the fact that it has been pointed out by the office that appropriate order is passed due to typographical. Considering the office note in presence record करते हैं counsel for the petitioner and state. Considering the office note, the criminal division number 421 of 2023 as mentioned in order dated 17 February 2022 is directed to be hereby the case number is hereby corrected to the criminal division number 441 of 2022. Office is directed to carry out the required correction in order dated 17 February 2022.
Here, serial number 4, Lord Sir. Item number 4. APP on behalf of.
For press filing item 6, Criminal Division 1190 of 2022.
May I please? The petitioner has challenged the order dated 7/9/2022, the page number 36. That is in impugning order, my lord. The petition of the petitioner under section 227 of CRPC has been dismissed. My lord, the case of prosecution, the grocery shop of the petitioner was searched on the secret information, and it is stated that 2.700 grams, 2 kilo 700 grams ganja was recovered, and accordingly seizure list has been prepared, my lord, and the ganja has sent for the FSL examination, and till final submission the charge sheet, my lord, the FSL report has not been received till late, my lord. It cannot be said the said commodity which is recovered from the shop of the petitioner, my lord, that is ganja or any elsewhere and anything, my lord. And in such circumstances, my lord, the trial court could not proceed under section 20B 2B of NDPS Act, my lord, as because the commodities which is recovered from the shop of the petitioner, that is not ascertained that is comes under the purview of NDPS Act or not. That's why the petition has been filed before the trial court, my lord, and the order dated.
Where is the petition filed before the trial court?
My lord.
Where is the petition filed?
Petition, though I have not annexed the petition, my lord. The order is there, my lord.
Where is the question of any petition to be filed prior to taking cognizance of this?
Cognizance has been taken. Cognizance has been taken, and this the
There is
case.
the question of filing any petition prior to cognizance of this. Are you to be heard prior to cognizance of this? Where is the petition? No.
This is
The charge sheet has been submitted.
yes, my lord. This is the discharge petition, and discharge petition has been dismissed
No,
by
this
the.
is not the discharge petition. You read the, oh, there is one more order.
Yes, my lord.
There are two orders you have annexed.
There is one cognizance order, another page number 36, my lord. The impugning order, my lord. May I permit to read the,
Just a moment.
my lord.
You just come here. Where is the case there?
Yes, my lord. Dated such and such file. The learned counsel appearing on behalf of the accused persons has submitted that nothing has been seized from the shop of the accused persons, has further submitted that the seizure list witness are highly interested witness and no independent witness has been examined. IO of this case has, in this case, it is further submitted that IO has submitted the charge sheet against the accused person without report of FSL Ranchi, and cognizance has been taken against under section such and such. It is not clear that seized substance is concubines, and this it has further been submitted that there is such much contradiction in the statement of informant and investigating officer. It has further been submitted that no case offence under section 20B 2B of the NDPS Act is made out against the present case. He has also argued that there is no antecedent ingredients of the
There are witnesses who are supporting the case. Who are these witnesses who have supported the case? They are the purchasers.
They are not purchasers. They are the police personnel below and other persons.
They are the seizure list witnesses.
Seizure list witness only the police personnel below. The police personnel is the seizure list witness. None of the independent person has come as a seizure witness, though the place of occurrence at the shop which is in the market below, and none of the independent witness examine and come forward as a seizure witness. They are the police personnel. No, none of the seizure witnesses are the independent person, and there is no any FSL report with regard to the commodities. I will annex the seizure list, my lord.
This FSL report cannot come during the trial?
No, my lord. The trial begins. Trial is going to begin as because charge is going to frame, lord. Prior to order taking cognizance and prior to submission of the charge sheet, the FSL report till late, my lord, FSL report has not been.
Show something that without the FSL report, charge sheet cannot be submitted.
Charge cannot be framed as because.
No, you just tell us. You have to show something that without the FSL report, the charge sheet cannot be submitted.
Then this case may taken up Monday, I will satisfied on that ground. Monday को जो रख दिया जाए हम कर लेंगे.
Where is the state? Where is the state?
State to.
State. उनको आने दीजिए.
रवि प्रकाश तो अभी नहीं होंगे, कोई और होंगे, क्योंकि स्टेट रवि प्रकाश छोड़ दिए.
कौन है?
उनके बारे में उनका होंगे एनडीपीएस का शैलेंद्र तिवारी.
हाँ बुलाइए मिस्टर शैलेंद्र तिवारी.
शैलेंद्र
नाम
तिवारी
फ्लैश करिए उनको बुलाइए.
वही होंगे.
Yes, madam, you want to withdraw? Yes.
It's a matter of order for defect. I asked for EQG call out over that.
देखिए criminal revision number 1092 of 2022. M.S. Chandana Kumari, advocate, under instructions of Mr. Anil Kumar, senior advocate, ASGI, submits that she has been instructed by the petitioner to withdraw this petition.
And the accused person Manga Singh and the victim both FIR has been quashed, Lordship. That's the reason we withdraw this petition.
She submits that the FIR in the present case has been quashed.
In the criminal writ number 623 of
In
2023.
criminal writ number 623 of
2023.
2023.
Order dated 6/9/2023.
6/9/23. By the order dated 6/9/23. Since the petitioner does not want to press this, and accordingly she does not want to press this petition. Since the petitioner does not want to press this petition is dismissed as withdrawn.
साइन कर दीजिए.
Item 7 WPS 7146 of 2023.
I've gone through the judgment which your lordship was lying upon.
Covered?
Covered.
It's covered, but the fact are the different, Your Lordship. Slightly different, not much. Fact are different.
What
Because
is the different fact?
different fact in the present case, no A certificate was there, so she has to appear before the she appeared before the medical board and they have assessed the age. First thing, and the second thing, he has filed the writ before her retirement, and the third one is she got no opportunity for correction of his date of birth. That's it. Yes, yes.
No opportunity to correct. What is the date of retirement?
Date of retirement is
31st of
December 2023, Your Lordship.
Prior to retirement, she has filed.
Yes.
on 14/12/2023,
And third one?
15 days before.
Third point is that she appeared at the time of employment, Your Lordship. She appeared before the medical board, and they have assessed the age of the petitioner, Your Lordship.
That's it.
Yes, Your Lordship.
Learned counsel for the parties are present. This petition has been filed for the following reason. The learned counsel for the petitioner has, the learned counsel for the respondents has submitted that the petitioner has sought correction in her date of birth
By Annexure 2, page 11.
Annexure 1.
Annexure 2.
by subjecting the petitioner to age assessment. Has sought correction in date of birth, which was recorded as back as in the year 1996. And she filed a petition for such purpose at fag end of her tenure only on 18/10/2022.
That has been rejected by Annexure 3.
Which has been rejected by Annexure 3 dated 8/12/2022 by indicating that as per service record, that the age recorded in her service record is final.
And the same is not under challenge.
That is not under challenge.
Not under challenge.
Yes, we have not challenged. We have challenged the
not under challenge.
We have challenged the only the Annexure 1. That is
That
the
order is not under challenge.
no.
The learned counsel submits that the order as contained in Annexure 3 dated 8/12/2022 is not under challenge. Otherwise, also the petitioner has taken steps to challenge her age recorded in service book at fag end. You are relying on this.
Yes, sir.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court in civil appeal number 1009 of 2022 within bracket Bharat Petroleum Coal Limited versus Shyam Kishore Singh.
Reported in 2020, Volume 3, SCC
Reported in 2020,
Volume 3,
Volume 3
SCC 411.
411. Volume 3 SCC 411, and let's refer to para
8, 9, 10, and 11.
para 8, 9, 10, and 11. To which counsel for the petitioner has submitted that there are three distinguishing features in this case. Firstly, there was no opportunity to correct the date of birth was ever granted to the petitioner. Secondly, the petition was filed on 15/12/23, and the petitioner has attained the age of superannuation on 31/12/23.
Yes.
And thirdly, at the time of employment, the age of the petitioner was assessed by the medical board.
Not as per the Annexure 1.
And the age was not determined as per the circulars of the
CIL.
It is CIL circular.
After hearing the learned counsel for the parties, and considering this court finds that the petitioner was appointed, that even as per the case of the petitioner was appointed in June 2001 on temporary post as General Mazdoor Category 1, and later her service was confirmed, and at the time of appointment she had no paper to show her date of birth, and accordingly she appeared before the age assessment committee to determine her age in between 30 to 35 years, and it is her case that at that time the age of the petitioner was fixed on higher side, ignoring the guideline of CIL. It is the case of the petitioner that upon coming to know regarding the wrong entry of date of birth, she immediately contacted the respondent authorities for change of her wrong date of birth from 35 years to 32.5 years, and that she had also submitted a representation to the Ministry of Coal on 21/10/2006, and thereafter she represented on 18/10/2022 for correction of date of birth, which has been rejected by letter dated age 12/2022. This court finds that even as per the case of the petitioner, she had full knowledge regarding recording of her date of birth, and as per the petitioner herself, she made certain representation on 21/10/2006, though a copy of the same has not been annexed along with the petition. Thereafter, the petitioner did not take any step for the purpose, and ultimately filed a representation only on 18/10/2022 before the respondent number 1 seeking correction of her date of birth, which has been rejected by order dated 8/12/2022. The said order is also not under challenge in the present proceedings. This court finds that here the petitioner has challenged the date of birth almost at the fag end of service, and the present petition was filed just 15 days prior to her date of superannuation. The judgment passed by the Honorable Supreme Court reported in bracket 2020 bracket close 3 STC 411. It has been held that the dispute regarding date of birth cannot be entertained at fag end of service. Paragraph 8, 9, 10 and 11 are considering the opposite facts and circumstances. This court is not inclined to grant any relief to the petitioner as played for in this petition, which is accordingly dismissed.
Order of reaction I have annexed, Your Lordship.
No, that has not under challenge.
Both the,
That is not under challenge.
yes. That's it.
You raised in 2006, so you knew since 2006.
That is the fact. I
That is a
can't.
fact.
And that has not been annexed.
I can't.
Mr. Tiwari, are you there?
Item 6.
Yes.
There is one NDPS matter. The learned counsel is saying that without obtaining the copy of FSL report,
Yes.
the charge sheet could not have been sent. Because there is no material to say
I don't
that
know.
whatever was seized was gone.
आइटम 6 मेरा नहीं है।
हाँ, कौन सा है? आप ही है ना NDPS में?
नहीं
पहले मिस्टर
हम
रवि कुमार
साइबर में नहीं, रवि कुमार का जो अदर मैटर है सो दूसरे को, क्रिमिनल रिवीजन दूसरे को हमको सिर्फ क्रिमिनल पे डीबी उनका है।
एनडीपीएस के कोई स्पेशल काउंसिल
अभी नहीं, वो वैकेंट है एनडीपीएस का।
ये मिस्टर पंकज कुमार को बोलिए, ही इज द मास्टर इन एनडीपीएस। वो है अभी स्टेट में? हाँ, उन्हीं को बुलाएंगे,
बुला
वही बताएंगे उनको, उन्हीं को बुलाएंगे, मिस्टर पंकज कुमार। He is the head PPP, API.
Yes, yeah, he is PP, public prosecutor.
Public prosecutor. So he is the head of all.
Head of the.
Call him please.
I am in cyber crimes.
From date list, orders with effect item 2, criminal division 11177 of 2022.
All secrets has been removed. Yesterday I have filed the court fee and type copy press
There is a
copy.
petition for convocation or delay.
One petition
How much is the delay?
129 days.
What is your explanation?
Explanation that she is under medical treatment. I have annexed the copy.
It is criminal division 1177 of 2022. No, there are other defects also.
No, I have removed. Type copy, press copy and court fee has been filed yesterday. It is
94 has been removed. 97. There are certain surviving defects. Anyways, counsel for the petition submits that the remaining defects has been removed and the petition has been filed seeking convocation of the delay. Issue notice to the opposite party number 2 in the middle petition as well as limitation petition for which requisites under registered under speed post as well as auxiliary process be filed by 29 February 2024. Place this case under appropriate hearing on place this case on 14th of March 24, awaiting service report. Office to track speed post delivery.
Item 3, criminal division 1180 of 2022.
Leadership training for 2 weeks time to.
Time till 1st of March. The 7th of March is granted to the petitioner to remove the surviving defects promptly. If the defects are removed within the stipulated time, the matter is directed to be posted on 14th of March 2024 under appropriate heading. If the defects are not removed within time, office is directed to prepare appropriate office note and communicate the order to the and take steps and communicate the order to the limit. So you do paragraph in the form.
Item 4, criminal division 1194 of 2022.
Same order?
Item 5, Resolution 1201 of 2022. Item 6, Resolution 1202 of 2022.
2 weeks will be granted in this.
Item 7, Resolution 1203 of 2022.
Your Ladyship, there are currently 3 defects which are existing. Defect number 91, that is the cage column is missing in impure order.
Defect 9 to be ignored.
Defect number 91, that is cage column is missing.
That is important, no? Because that will give the, what is the date of improved order? What is the date of improved order? How do they calculate the limitation without the cage column?
Your Lordship, that is defect number 92. We need to file limitation also, Your Ladyship, but after defect number 91 is removed, Your Ladyship, we'll file a fresh.
You file your, you file fresh certificate.
Yes,
But fresh certified copy will not serve the purpose, no? Because you have already obtained a certified copy. Then it comes to further petitioner, place for time to remove the defect or to file an appropriate petition for ignoring one or the other defect. You file a petition, you will ignore.
Yes, Your Ladyship.
The needful be done by 7th March, post on 14th March or thereafter.
Your Ladyship, for defect number 93 also, that is
You file a
pagination.
petition.
Your Ladyship, that is regarding pagination and that will be corrected in due course of day.
You can remove the defect. Any defect, the petitioner may choose to remove any of the surviving defects in the meantime.
Obliged.
Item 8, Resolution 1207 of 2022.
3 weeks time. Surrender certificate.
Same order. I am giving time till 7th of March.
Item 9, Resolution 1223 of 2022.
This is surrender certificate that will be filed before.
Item 10, Resolution 1236 of 2022.
सिर्फ इसमें सरेंडर कर दिए हैं डिफेक्ट रिमूव करने के लिए टाइम
Sorry?
सरेंडर कर दिए हैं
You file, you remove the defects.
यस टाइम दिया जाए
Time to remove the defects.
Item 11, Resolution 1248 of 2022.
Surrender certificate.
Item 12, Resolution 1249 of 2022. Item 13, criminal division 1251 of 2022. Item 14, criminal division 1259 of 2022. Item 15, criminal division 1268 of 2022. Item 16, criminal division 1270 of 2022.
Yes. Weeks.
Item 17, criminal division 1271 of 2022. Item 18, criminal division 1277 of 2022.
Which time will be by 7th March?
By 7th March. All the orders are by 7th March, but they are all paid.
Item 19, criminal division 1279 of 2022. Item 20, criminal division 1284 of 2022.
2 weeks time. Same order. By 7th.
Item 21. Item 21, criminal division 1291 of 2022. Item 10, item 10 from supplementary list. Item criminal division 735 out of 2022.
This was the case. I will just dictate it in the second.
Yeah.
I have not been able to go through it.
Great.
I do the input in the lunchtime.
Also, can I request one? If in case my absence is there, she is going to, if she's there, her presence of it is accepted only.
Oh yes, your presence will also be recorded.
Great.
You just prepare your appearance.
Great.
From daily list for final disposal, item 1, WPS 1.
I'm sure that she is aware of the gist of the submissions. You just prepare a gist, right? You can have it in your handwriting also, so that nothing is recorded. In half a page you do it. Okay?
For final disposal, item 1, WPS 5107 of 2017.
Yes.
Are you?
This petitioner, he initially made a prayer for consideration of his case for the benefits of the consequential monetary benefits of the 5th, 6th revised pay scale.
What is the prayer now?
And thereafter, in addition to that, since during pendency of this writ petition, order passed on 25/8/21 from the office of the Honorable Chancellor, refusing to consider the claim of the petitioner for regularization of his services. That order, by way of amendment, has been sought to be challenged, and that was allowed. And thereafter, the amended writ petition has been filed.
Please place your relief on the amended report.
It is at page 8 of the amended writ petition, the prayer added by for issuance of an appropriate writ for quashing of the letter number so and so dated 25/8/2021, which is annexure 15A, page 1, issued under signature of the Under Secretary, Honorable Governor Secretary of Jharkhand, whereby case of the petitioner for regularization of his services in the university service on the post of lecturer of English in KS College Saraikella has been rejected, and the petitioner further prays for issuance of writ authorization commanding upon the continuing payment of pension, pensionary
So
benefit.
everything will depend upon the legality and validity of this.
Yes, because now
Your other prayers will also be dependent on that.
yes, because that is the reason that it has not been given to me. Though I was given the 4th revised pay scale, UGC pay scale, that was sanctioned.
You can come to those dates later. Now, you place the impugn order first.
Yes, that is at page 156.
Yes.
It is a communication from the office of the Rajyapal Sachivalay, and it is addressed to the Vice Chancellor of the Kollam University. And the subject is like this: regarding submission of the report of screening committee dated 28/8/2019, constituted as per statutes. Page 156.
156. This is dated
25/8/2021.
25/8/21. This is the subject.
Yes, the subject. Beside, after the address portions.
Yes.
Regarding submission of the report of screening committee dated 28/8/2019, constituted as per statutes in respect of Sri Kusheshwar Prasad Singh, petitioner, temporary lecturer of English, KS College Saraikella. And the reference is also there, Kul Sachiv Kollam Vishwavidyalay, letter dated 21/9/2019. Then, निर्देशानुसार उपयुक्त विषय प्रासंगिक पत्र के साथ संलग्न स्क्रीनिंग कमेटी की बैठक दिनांक 28/8/2019 के आलोक में माननीय राज्यपाल सह कुलाधिपति महोदय द्वारा निम्नांकित आदेश पारित करने की कृपा की गई। Statutes for regularization of the service of purely temporary lecturers appointed on or before the 28th February 1982 as approved by the Chancellor by letter number so and so dated 29/1/86 की खंडिका 1D निम्नवत है: a purely temporary lecturer who is in the service of the university or of a college admitted to it as a lecturer shall be appointed by the syndicate or the governing body as the case may be in the regular service of the university or the college concerned if he fulfills the following condition. The condition number D has been referred, that the appointment had been made on the basis of advertisement of the post in the Indian Nation, Searchlight, Aryavarta, Pradeep, or in any other daily newspaper of Bihar state, in a leading newspaper of India, and from the panel recommended by a selection committee constituted by the university college for the purposes assisted by an expert or experts. Uparयुक्त स्टैचूट के तहत गठित समिति की दिनांक 28/8/2019 की कार्यवाही में यह स्पष्ट उल्लेख है कि श्री कुशेश्वर प्रसाद सिंह नियुक्ति के समय सर्चलाइट में विज्ञापित उच्च द्वितीय श्रेणी 52.5% की आवश्यक योग्यता नहीं रखते थे। इन्हें मास्टर्स डिग्री में मात्र 46% अंक प्राप्त थे। कॉलेज के अधिग्रहण टेक ओवर के समय भी इन्हें निर्धारित योग्यता नहीं थी। यह सही है कि इनकी नियुक्ति सर्चलाइट अखबार में विज्ञापन निकालकर हुई थी, पर सर्चलाइट में निकाले गए विज्ञापन का आलोक से भी स्पष्ट है कि उसमें उच्च द्वितीय श्रेणी की योग्यता मांगी गई। अतः यह स्पष्ट है कि इनकी नियुक्ति विज्ञापन के शर्त के अनुरूप नहीं थी। अतः यह निष्कर्ष निकलता है कि इनकी नियुक्ति के मामले में उपर्युक्त कंडिका 1D में निहित शर्त का उल्लंघन हुआ है। रेगुलराइजेशन का लाभ उन्हीं व्यक्ति को दिया जा सकता है जो उपर्युक्त स्टैट्यूट की सभी शर्तों को पूरी करते हो। चूँकि श्री कुशेश्वर प्रसाद सिंह के मामले में स्टैट्यूट की कंडिका 1D की पूरी नहीं होती है, अतः इस मामले में समिति के अनुशंसा से असहमत होते हुए इनकी सेवा के रेगुलराइजेशन को अस्वीकृत किया जाता है।
Just one thing I want to know from you. This KS College, Saraikela.
Yes.
Was it one of the colleges for consideration before Agarwal Commission?
No. It was in earlier phase.
Not a part of Agarwal
No.
Commission. Now you come with the dates.
Yes. Petitioner, he was 22/12/76. The petitioner was appointed against a leave vacancy on temporary basis to work as to teach English as lecturer in Kasi South College, Saraikela. That is 22/12.
That's right. And you continue.
Yes.
Then what happened?
Thereafter, petitioner joined in pursuance
Against
of
leave vacancy.
yes, 22/12/76 was the appointment letter, and he joined against the leave vacancy on 2/1/1970.
Advertisement is 29/7/17.
That is subsequent. These are the earlier 2/1/77, and thereafter he was working there. In the meantime, he joined on 2/1/77 against leave vacancy. He was working in the meantime on 29/7/1978. The advertisement was
That
published.
I've seen.
Yes.
What do you mean by secretary of the governing body duly approved by UGC?
Duly approved by University Service Commission.
University Grant Service Commission.
Page, I will just refer to page 128.
Page 120. So where you say duly approved by University Service Commission? Approval was granted later.
That concurrence is later on. There is a pleading in the
Is there?
that a panel was there for the purpose of this selection in pursuance of these advertisement.
Show me from where you say that your appointment was duly approved.
No, here there was no approval at this point of time.
So should I delete that?
Yes.
All right then.
Thereafter, the 1/9/1978, the petitioner gave joining in pursuance of his selection, and thereafter the petitioner continued as such And then 28/1/1980, the Secretary Bihar University Service Commission gave temporary concurrence, annexure 5, page 131. That is a temporary concurrence of petitioner and along with other teachers. 131 marked as annexure 5. It is in Hindi. Yes, it is by Bihar Vidyalaya Seva Ayog, and it is addressed to the कॉलेज शिक्षकों की नियुक्ति निर्देशानुसार उपयुक्त विषय के संबंधित आपके पत्र संख्या 100 दिनांक 19/1/79 के प्रसंग में मुझे कहना है कि यह आयोग बिहार विश्वविद्यालय सेवा अधिनियम 1976 की धारा 1 एवं बिहार राज्य विश्वविद्यालय द्वितीय संशोधन अध्यादेश 1989 की कंडिका 11 के खंड अंग के अंतर्गत निम्नांकित शिक्षकों को अस्थायी नियुक्ति में पदभार ग्रहण अथवा पद सृजन की तिथि जो बाद में हो से 1 वर्ष की अवधि तक अथवा सेवा आयोग के अनुशंसा निर्गत की तिथि से 3 माह तक अथवा सेवा आयोग के अनुशंसित अभ्यर्थियों की नियुक्ति की तिथि तक जो पहले हो.
This was for
temporary concurrence.
Conference for 1 year.
1 year. कार्यरत रहने हेतु सहमति प्रदान करता है. And the name of petitioner is at serial number 6. And then the last just after serial number 7, I'm just stating the content. इस सहमति के फलस्वरूप सेवा आयोग उप शिक्षकों का साक्षात्कार में बुलाने हेतु अनुबद्ध नहीं होगा. So, since this was a screening and approval, so there was no further need of interview. And one thing would be relevant for the purpose of this writ petition. A copy of this temporary concurrence was sent to the registrar Ranchi University. The endorsement made in the bottom of this communication. It was also sent to the Education Department, Sanjukta Sachiv Shiksha Vibhag, and then the copies to the concerned teachers. So this was well within the knowledge of the university and also the education department, apart from the college. Thereafter, 11/12/1980, the notification was issued by the university, Ranchi University, about taking over of the college, that is the Kasi KS College Saraikela, as a constituent unit of Ranchi University, and it was made constituent with effect from 24/11/1980. And this constituent is constituent as within the meaning of the constituent as defined under the Bihar Jharkhand State Universities Act. It means the college is admitted under the university. It will come under the direct control and administration of the university. It is no more a affiliated college, it is a constituent unit. And this making of this constituent is also preceded by an agreement made between the college and the university authorities.
Pursuant to the department letter issued by the education.
Yes. It has the act also says that it requires the sanction or approval of the government. That is important. And one thing is important for the purpose of this writ petition, that it is along with all the assets and liabilities, along with the employees also, teaching, everyone. this letter is at page 132, which is addressed to all the concerned university and
Then you
office.
have the statute.
Yes.
This statute came when?
This statute came. This is dated 18/11/1980.
Bottom portion.
Bottom portion, page 133. This statute, my case was not considered as per this statute. Earlier it was said that it will be considered under this statute, but my case was considered under the next statute, which is at page 135, which is referred in the impugned letter also.
Statute, relevant statute is?
28, that is dated 29/1/1986.
28.
It is applicable for regularization of the services of purely temporary lecturers appointed on or before 28 February 1982.
This is the statute.
And yes, under this statute, the case of the petitioner has been considered and rejected. And this statute was approved by the Chancellor on 29/1/1986. That is page 155. May I read out this? Because the petitioner would contend that a serious error has been committed while rejecting the case of the petitioner by appreciating 1D and without reading this statute in totality. This is a regularization scheme.
Yes. Thank you.
With effect from the date of the order of the Chancellor under section 5 subsection 2 of the Bihar Inter-University Board Act 1980, the undermentioned criteria shall be followed for absorption of purely temporary lecturers in the regular service of the college or of a college admitted to the university, like the present college, other than the college managed and maintained by the state university. Number 1, a purely temporary lecturer who is in the service of the university or of as college admitted to it as a lecturer shall be appointed by the syndicate or the governing body, as the case may be. My case it is governing body, in the regular service of the university or the college concerned, if he fulfills the following conditions. A, that he had been appointed as lecturer in the service of the university or the college concerned on purely temporary basis on or before 28th February 1982.
You satisfied this?
Yes, I have been appointed after advertisement in 78 and has been since then continuing in the service of the university college as such. This condition is also satisfied. Then number B, that he possesses at least a second class master's degree in the subject. This has not been appreciated and considered. That he possesses, the language is that he possesses at least, the word is at least, prefixed by at least a second class master's degree in the subject. And this is only for the purpose of consideration of regularization. Then C. This honorable court may kindly mark the words at least, maybe. That the post on which, C is that the post on which the lecturer concerned had been appointed was duly sanctioned by the competent authority, or the proposal for sanction of the post.
There is no dispute.
No. We have documents also and they have not list also. Then D. Now D is the bone of contention among them. That the appointment had been made on the basis of advertisement of the post in the Indian Nation, Searchlight, Aryaprata, Pradeep, or in any other daily newspaper of Bihar state, or in a leading newspaper of India, and just come to after one page, page 137, because it is 136. It is a double page in a page 1. Page 137. Panel recommended by a selection committee constituted by the university college for the purpose assisted by an expert or experts. Now D, it has been considered like this. Panel selection committee constituted by the university for the purpose assisted by an expert or experts. The second part of D is not disputed. The first part of D is said to be not fulfilled. In the impugned order,
the appointment has been made on the basis of advertisement. There is no dispute.
But because of this reason, my case has not been considered.
No, that is not the reason.
No,
They say that you do not have higher second class.
And they say it on basis of that the advertisement stipulated higher second class, so it is not in terms of the advertisement. That is their case, and the petitioner would contend that this advertisement was only for to see that there was a transparency, and it was giving opportunity to all eligible persons.
But as per the statute,
B.
at least a second class.
Second class. This
And
thing.
you have second class.
Yes, at least I have 46%. That is mentioned in the MP
So
letter.
your contention would be at best
Yes.
that clause B has been ignored completely.
Yes, ignored.
But it has been substituted on 17/12/1987.
17 to 1987.
17 to 1987.
87. 17 to
And you
19.
are governed by this only. You
Yes.
are governed by this.
Yes, this.
It is not the case that B is not applicable.
No, we would be applicable.
Would be applicable.
Yes. They are not coming with a case that 17 to 87 amendment or addition would be prospective or something. It is not their case. The case is that the advertisement stipulated higher second class. I did not possess higher second class, and they are not reading this scheme in totality, because this is a scheme. So certain exemptions
We
are.
hear it in second half. I have to do something in second half, and then I think it will be taken up after few patients.
Item number 23, I pray from today only, Lordship.
23 is what?
Daily causes are
It
20.
may not be taken up. You don't
If it is taken up,
we do not know. You see, we cannot keep a record of what is happening. I do not adjourn cases on mentioning. Please don't mention.
My lord, I agree to my lord. This is a Ravi Prakash matter, my lord. There is no special PP now. So all the matters of Ravi Prakash criminal division have been transferred to P.K. Chatterjee.
No, you see, this is NDPS.
Yes, NDPS, my lord.
Nobody is appearing, and it's a very technical point
Yes,
which has
Lord.
been raised. The council says that the sample of the item was sent for FSL examination, and the charge sheet was submitted, and cognizance was taken under NDPS. So he says that there is no material for that. So you please take care of this. We are not concerned as to who is there, and I am aware that you know NDPS quite well. You being the PP, because this is something which might be regularly happening.
Yes, sir, lord.
So you have to simply show that the FSL report can come at any time.
Yes, sir, I can.
That is it.
Ladyship, my case is next, so please kindly note it.